I'm executing my first order. You must go to court or go to the CCMA and query or bring an application or whatever he needs to do to rectify the problem. CCMA, Mr. Boyson, again, if you could assist us there, how best you can handle this problem.
Thank you, Mr. Murugan. We certainly take great care in ensuring that we get the correct party details. Over and above getting the details from the applicant party, prior to a scheduling of the matter, our officials do contact the parties to remind them of processes. We do follow-up calls to parties to ensure that to secure their attendance. Even on the day of processes, we take every effort to contact respondents, employers, to inquire on the absence at a process, and we give them an opportunity then to appear before the CCMA. We most certainly take that extra precautionary measure to ensure that we don't proceed if there was an issue with the service. We and you probably find from many of our processes, any commissioner, once they understand that the service is defective to the respondent, they will stand that matter down for proper service to the respondent. We do take cognizance of the question that was posed, and yes, we do take every care to ensure that the parties are cited correctly. And we are well aware that in order to have an award enforceable, the parties have to be correctly cited in their correct capacity. And we take care in detail to that. Obviously, where the applicant is unable to provide us with the correct and full details, when we initially schedule a matter, it will become apparent when the respondent does not appear. We make the necessary follow-ups to ensure that we have the correct details. But your point is noted, and it's something that is worked on continually between the CCMA and the applicants who are from the vulnerable sector mostly, who might not be legally sophisticated to provide us with all the correct details. And we probe these issues with them to get the correct details. Thank you.
Thank you, sir. I'm just going to follow up. I just want to. Yes, sorry, Mr. Burton.
No, it's Moro.
Moro, you can continue.
Thank you. Look, over and above what the Senior Commissioner has indicated, as the CCMA, we have a practice that assists in that direction. For example, in certain companies, trade unions, employers organization, we put their details already on the system. So when a person comes and say, I work for Moro Pty Ltd, we would mostly get the information from the system, because such companies would normally update their contact details regularly with our offices. So that also assists and reduce the problem that now you are mentioning. So it's mostly in the vulnerable sector, and as part of trying to also minimize the reworks on our part, we will from time to time call the respondents as and when they do not come, or if they do come, obviously that is resolved. But that problem would normally happen where the respondent may have not attended, and we proceeded on the basis of the information that we got from the applicants. Of course, normally in the vulnerable sector, we appreciate the hardships that the applicants would mostly go through by not having the details of their employers. But as our effort, we try, as we indicated, to try and get the correct details. But where the applicants may not be able to provide, that's where unfortunately we experience such problems. But in the main, there are efforts. Thank you.
Thank you, sir, for the response there. Just a follow-up on this very same point while you're on screen. Another difficulty that sheriffs nationally experience when enforcing these awards, especially on companies, we find that when we our first attempt to execute the enforcement award for both this applies to both the National Bargaining Council and the CCMA matters, we find that the first response is that the respondent would say, hang on, we didn't get any notice to attend an inquiry or attend arbitration or attend the CCMA hearing. And this is the first time that we're hearing of this matter, which immediately now creates this difficulty for the deputy sheriff or the sheriff if he's serving on his own, in that there's obstruction to say, hang on, I don't know anything about this, especially these major companies and big companies where they have legal backgrounds and they have legal experts assisting them and try to obstruct the sheriff. We actually brought this point or raised this point in our meeting with the Deputy Minister and of Labor and the Deputy Minister of Justice in our last engagement with them in 2019, I think it was. I was part of that meeting with them. And we raised this point with them, saying that CCMA and National Bargaining Council should consider involving the sheriff in the service of those notices to these respondents, which is the initial phase of the whole dispute. And in that way, like how the attorneys or legal practitioners would engage the sheriff's services in serving the letter of demands, then the sheriff already have history behind him so that he can assist his deputy sheriffs in enforcing. This is another issue that causes delay as well. I know at that point, in fact, all our engagements with the CCMA resulted in the fact that it is a budget constraint because of the volume of your letter of demands or your notices to these respondents. You are unable to engage the sheriff's services. But it's a matter that constantly pops up, and it constantly pops up in the sheriff's profession because of the unknown. When a deputy sheriff is on the property, hang on, I'm not allowing you to do anything until I get the opportunity to understand where this matter comes from. And that is when the rescission application comes in or the appeal comes in. What are your thoughts, Mr. Sedlako and Mr. Boyson?
Thank you, sir. Look, the problem remains. You may know that we have been in the news with some of the stakeholders, complaining about the fact that at some point, our doors were closed. But the budget issue, as you may know, remains an issue. It's a problem still, but in the main, from our observation, the manner in which we are effecting services working properly, there are challenges we acknowledge, but in the main, I think, our efforts in going the extra mile with the examples that the senior commissioner gave are really assisting a great deal. Of course, there are instances where there are such challenges, but then Section 144, for example, by way of a rescission, will accommodate them. There are, for example, other respondents who will, of course, when they are caught in the process, claim to have not received. There are instances where we have been able to prove that, no, we have served them and here is the proof. But where they still have issues, they can invoke, Section 144 provision in terms of the rescission. And in certain cases, they fail. In certain cases, they succeed. It's part of the process. But I think our efforts, are paying off. Unfortunately, utilizing service of the sheriff in serving the notices, as you correctly pointed out, depends on the funds, which we don't have, unfortunately. And we will continue and try and improve where we can. Of course, with budgetary constraints, there are other challenges, that comes with certain things. So, yeah, I think in the main, I would think we're doing well. We accept that there is still a problem here and there, but it's not quite a major problem. And where there is a problem, Section 144 is there to cater, for that situation, among others. Otherwise, then reviews, for example, if they are to not succeed in rescissions. But yeah, we prepared to continue to look into that.
Thank you, sir. Thanks for your response. Ms. Bovona, if you want to come in. Boniswe, do you want to come in, ma'am? You had your hands up.
Yes. We would just like to find out from the NABC side, what is the expectation? What do you mean when you are saying we must involve the sheriff when we are sending notices to the parties? I think we need clarity there.
Okay. The clarity is that when you initially, when these applicants engage your assistance, you obviously, one of the requirements is that notice must be given to the respondent to come to a hearing. Am I correct?
Yes.
And I think the rules provide, or your requirements is that you can email this notice to them, or hand deliver, the applicant can hand deliver it to them. We are saying, as the sheriff's profession, involve us at this stage. Get the applicant or yourself to engage the sheriff to go and serve that notice to the respondent. In that way, we are involved from the inception of the whole process. Rather than the applicant now emailing it to them, we are not sure, we don't know your processes, your internal process. How do you verify that this notice was actually received by the respondent, whether the email went through or not, or whether the applicant did go and deliver that notice to the respondent? So the sheriff's profession is saying, engage the sheriff's profession in formally serving your notice to the respondent to appear before the CCMA. Put it that way.
Mr. Murigan,
yes.
Ms. Mbovane, if I can just come in with Mr. Murigan there and Mr. Setlaku. We understand the budget contracts. We are not blind to it. We are not oblivious to that. Our concern is, though, that should we be able to initially serve the first, whether it's just the first demand, we don't need to. I don't even think you need to do the whole process, but the initial process document that starts the process of informing the respondent of the proposed action against it. That will say that, I'm going to use figures now, and don't hold me to it, I'm using it as an example. Say that service costs the CCMA 200 Rand. I'm using the CCMA as an example. By the time we get to a removal stage, where the costs for a removal is anything between 1.5 and 6,000 Rand, depending on what has been attached, if not more, that could have been avoided had the applicant done due diligence, or not the applicant, the respondent, if he had done due diligence once he had received the document, and you then had proof that he received it. Because what we currently find is that a lot of money has been spent on attempted removals not proceeding because of incorrect information, and that causes a financial restraint or pressure on the CCMA at this stage, because we still forward and give them their returns, and those are still funds that are outstanding to the sheriff. But had the process started with the sheriff, I personally, and that's my opinion, personally think that the CCMA will find that their budget reduces quite a bit in terms of the excessive amounts that need to be paid on removals, goods in storage, then goods being released after 2 years in storage. So it's just an opinion of mine. I'm just making an observation that can be considered, but that's from my side. Mr. Dube has his hand up, Mr. Murigan.
Yes, Mr. Dube, if you can continue, you can raise
Thank
your
you,
point.
Mr. Murugan. And I think it's just a suggestion. Maybe we can work around it. I think the previous question dealt with the distribution of contacts for people, because when the CCMA issues this enforcement, already from our side, we are satisfied that the employer was contacted. I think maybe if we can work around, if the employer is saying I was not served, maybe let's strengthen our communication between the sheriffs and the certain office of the CCMA or the council, of saying there's this allegation that they never received. In the file, do you have proof that you've served them? Because I would imagine, as the employer, my first defense will be I was never served. It's the first time I'm hearing about this. So I don't know. I think maybe we can work around that because we have proof from our side that processes were done diligently. Thank you.
That will be a good idea. That would be a very good idea if you can attach that proof to the enforcement award or have it available for the sheriff when and if he experiences difficulties. And yes, I support your idea of enhancing the communication channels, which I must say has improved since our meeting in 2019, but a lot has to be done. As you know, people are desperate out there and every cent counts for them. So, and they rely on you and I to get those funds for them. I want to give Boniswe a chance. She's got her hand raised again.
Yeah, thank you, sir. It's not Boniswa, it's Maggie. We're having a problem with our connection here.
Okay. You can continue.
Yes, I just wanted to clarify this. In a case where parties are involved, let's say an applicant who's working for this company and this company, the bargaining council do not fund. We do not pay the sheriff as the bargaining council. It is the duty of the applicant to pay for him or for herself. And just imagine a person has been dismissed. They do not have monies to pay the sheriff. That is going to be a challenge for us. For instance, the CCMA used to pay, I don't know, the CCMA will clarify this if they still do. They used to pay for applicants and bargaining councils did not. So I'm just scared that it will give a wrong implication to employees that the council is going to pay for me. Always when you send communication to, when you send the writ to the sheriff or when the applicant delivers, we specifically write that we are not responsible for paying. I don't know whether some sheriffs ignore that because they'll always send the statements to the council and then we go back and say, no, this is not ours. For instance, we do have cases, our own cases at the bargaining council, where we want to enforce awards, you know, for levies, for whatever, where the applicant is the bargaining council. We don't even open accounts with sheriffs. We pay upfront because we're trying to avoid this thing that you do have an account with us. If you can just try to work around those. There are sheriffs in some areas where we do have an understanding. They now understand how we're working, you know. But it's going to be difficult to do all those things for the applicant. It's going to be very costly for the bargaining council. Remember, the bargaining council is not funded by the government. It's funded by parties through levies. So it's something that we'll have to go to executive meetings to say it's really going to be costly, I can tell you. But we are prepared to hold meetings with the CCMA, who accredit us to do these cases, to discuss this matter further so that we can take something back to the sheriffs. This is how we think we're going to work around this thing. But we really appreciate that something is coming up that can resolve this matter. Thank you.
Thank you, ma'am. You raised a very, very important point and something that sheriffs have been grappling with on the ground for a while now. And your clarity that the bargaining council will not finance or will not pay sheriff's fees on behalf of an applicant really poses a very serious concern for the profession. As a practicing sheriff, I'm thinking, hang on, what happens now when these applicants come to my office with those enforcement awards and they don't have the money to pay for fees? What do we do? So I think to the sheriff's profession, the 190 participants that's online, it's a very important point to take into consideration or to note in your offices that the bargaining council has now confirmed that they will only pay for matters that they are instituting. In other words, if the applicant is the bargaining council, as Madam pointed out, that they would sue for levies due to them. In that case, the bargaining council will be prepared to pay sheriff's fees. If it is an applicant that is bringing the enforcement award to the sheriff, then the applicant needs to pay the sheriff's fees in order to execute that enforcement award. And it's not only to execute that enforcement award, it comes with various other fees, the sale costs, the removal costs. So it's a challenge that I think is very important for the bargaining council to consider and give proper direction to the applicants when they come. I noted your statement when you say that in your covering letter, you state that the bargaining council is not prepared to or not willing to pay the fees of the sheriff. So I think this is a note to sheriffs to keep a very close watch on this matter and obviously advise the applicant accordingly and obviously demand your fees or request your fees up front. Thank you, ma'am, for that. But I'm hoping that there's further engagement between you and the CCMA or the relevant stakeholders that you can engage with in order to give clarity to these applicants.
Mr. Morrigan?
Oh, yes, sir.
Just again, I'm sorry if I'm interrupting, but just just to follow up on what the lady has said, and I totally agree with her. When we receive, I'm talking about in my area now, when we receive the national bargaining documents, most of the letters, most of the processes have a covering letter to say that the bargaining council is not responsible for the fees of execution, which is liable by the applicant. What concerns me though is the CCMA do not have covering letters, and the CCMA covers costs for individuals up to a certain income. There's a sliding scale where they stop and say the CCMA, if your income, I'm using an example again, if your income of the plaintiff or the applicant is less than 200,000 Rand a year or was, then the CCMA will cover the service and execution fees of whatever document is being served. But they do not give us clear instructions in a letter to say that this person earns more than X amount. We do not know what the process was that was followed during the process at the CCMA. So we're unaware of how much this person earns and who's liable for the account. So if I can suggest that if the CCMA sees it fit and they can do it and it's possible, just a covering letter to say this account is due by payment by the applicant, the CCMA, or alternative, the CCMA is liable for this account. But that's just a suggestion, because it's terrible when the individual stands at your counter at reception and the person is not aware that he needs to pay for this certain things, or that there's limitations in terms of what the CCMA will be paying for. And then just there was a comment made in the chat section by Tertia to say that a list of all contact details for the provincial contacts have been forwarded to the sheriffs on multiple times. If I may request, can we not ask that that list be sent to the board, even via Mr. Nell or Bernadine's email address, so that we can get permission from the board to post that contact list on the board's website, so that if a sheriff has an issue or has the need to contact somebody urgently, he can at least go directly to the website and obtain a number on the website that is available to them. But just a suggestion. Thank you.
Thank you, Mr. Burton. Colleagues, participants on the Q&A, I am looking at your questions and I'm raising them as we go. Maybe I'm not announcing your name, but I'm deliberately leaving out the Rule 38 indemnity for now, because I want to give enough time for us to discuss that issue. Mr. Kolani, you want to come in? Who is Mr. Kolani? Is he a participant or a panelist member? I don't see his name on my list. If he's a panelist member, then he needs to go follow the Q&A. Mr. Morwa, you want to come in? Your hand is raised.
Yeah, look, we just want to clarify this issue of the threshold, because we can only pay for those that fall within the threshold. If you earn about 224 per annum, then you do not qualify for the administrative assistance of the CCMA. So every award that we send to you for enforcement will have the covering letter if that person qualifies for that assistance. Where there is no letter of our commitment to pay is because the person may not be qualifying. So if he doesn't qualify, then he or she becomes responsible for his or her own, enforcement. So that is the distinction. So every time you receive this, just check those letters and you would be able to also know from the applicants how much they were earning, and then you can see that this person therefore does not qualify. And if he qualifies, we issue such letters to take care of, the payments only when the respondent is not able to cover the cost during, the enforcement process.
Thank you, sir. While you just stay on screen if you don't mind, and maybe Mr. Boyson can assist us here as well. There's a few questions that I got from Tanya regarding your processes. She wants to know whether the CCMA has any legal experts within your department to give legal advice to the applicants in regards to the process that will be followed once the enforcement award is issued and sent to the sheriff. For example, do you have any way that you can assist the applicants with drafting of the sales notices and publishing the sales notices if it has to be published in the newspaper? Generally, it's something that lands on the sheriff's desks, and some sheriffs do not mind assisting in this regard. But in terms of the rules, it is the responsibility of the applicant or the applicant's legal representative. That's one question posed. The other one, I'm just going to read out two of them because it's interrelated. The other question she raised is, does the CCMA still covers the cost of the attachment and removal together with storage? Because there are circulars or we've been informed that certain CCMA departments are informing sheriffs that they cannot afford to cover the removal and storage costs any longer, or the advertising. So is this procedure changed, or is this the cost factor has changed in regards to your responsibility? That's the second. But do you want me to stop there and give you an opportunity to answer these two in the meantime, sir?
Okay, no problem. Let's start with the last one. Cost for removal and storage. What we are doing now in terms of removal and storage, we're trying to limit that. In most cases, we say, or in all cases, we say, don't remove until we give you an instruction to remove. But of course, after a lapse of time, we give instructions where we do not see any reaction, because there are times, and most of the times, either the respondent is going to comply, or he's going to go to the labor court to review, or he's going to apply for rescission. And we are now saying, don't remove until we give you the instruction, because we wait for the reaction of the respondent. Either they comply, either they go to the labor court, or they come to us in terms of Section 144. If we don't receive any of those things and there is no compliance, then we give you the instruction to remove. And of course, we try and limit the number of days, because we are also worried about the budget that we spoke about earlier. That removal and storage obviously are costs that, if minimized, we can be able to service as many applicants as we can. And I think that's where the whole thing is. We do pay for removal and storage, but we are trying to manage it, and we have successfully, in my opinion, managed it, because there are most cases where people then exercise their rights, such as 145 review, such as 144 rescission, or just compliance with their awards. In those cases, we then manage the cost in terms of those two. Now, in terms of drafting of documents, no, we don't provide such assistance. And we have just been relying on the sheriffs to assist. And obviously, if there are costs involved, they will be part of the process, because our position is that when you execute, get all the monies from the respondents, especially where you are able to get them to comply immediately or to tell their staff, recover your costs from there. Only when you cannot recover them, CCMA will take care of those. But we're not assisting them with the drafting.
Thank you, sir. Thank you very much. I got a question here from Tertius to the National Bargaining Council. To the National Bargaining Council, if someone, Maggie, can assist us here. Tertius says that on your enforcement award, on point 7, you state that it's a note that's made there. You must pay the applicant the amount due. On point 8, it says the cost incurred in the execution of the writ must be paid by the applicant. please explain, as the respondent says they are not liable for the fees, and how can they pay the fees? I think the National Bargaining Council, this question is posed to you. If you can respond, and I will assist when you respond. Maggie, if you're available.
Yes. I'm sorry, sir, I didn't hear the Tertius question.
Okay. Tertius says that on your enforcement award on point 7, your enforcement award says that you must pay the applicant the amount due. On point 8, it says the cost incurred in the execution of the writ must be paid by the applicant. He says, please explain, as the respondent says that they are not liable for the fees, and how can they pay the full amount due to the applicant as my fees has not been paid. Now, I think that the issue here is that on your enforcement award, generally the enforcement award would say that the respondent is liable to X amount plus interest plus costs. So I think what you need to do is you need to look at your enforcement award, and although the applicant is paying the cost, that cost must be recovered by the sheriff at the end of the day, over and above the capital debt. So you need to look at your enforcement awards and ensure that it specifies that the respondent is liable for the judgment debt, cost, and interest, so that when the sheriff is approached or executing this enforcement awards, he can enforce it in the actual drafting of your enforcement awards. So you need to look at point 7 and point 8 to say that the respondent is liable for all costs.
Thank you, sir. If I may ask, is she specifically talking about a particular enforcement award?
Well, he's referring to enforcement awards coming from you, from the Bargaining Council. I'm not too sure. I'm not too sure whether it's a specific Bargaining Council. I don't think sheriffs are aware that there's different Bargaining Councils represented here, or it's a national Bargaining Council.
I think so.
Maybe it's from a specific Bargaining Council, but if through your office, if you could assist us to somehow bring this to the attention of the national Bargaining Councils.
No problem, sir. If you can just send us specifics so that the National Association of Bargaining Council can look at that. Like you're saying, we are different bargaining councils, we're not working the same, although we are using the same legal framework. But just give us specifications so that you can see and assist.
Thank you, ma'am. Thank you very much. We'll do that. I'm sure sheriffs are listening to you, and they will obviously attend. There is a few repetitions, matters that we've discussed, like Mashego wants to know why can't the initial notification be given to the sheriff. We've addressed that matter already. I want to raise an issue that has been raised by the CCMA. CCMA wants to know, Mr. Burton, if you can come in here to assist me. CCMA wants to know, when a rescission application is processed, is the correct process then to reissue the enforcement, even if the enforcement period has not lapsed? Could the sheriff not wait for the instructions if the period has not lapsed? Mr. Burton, if you can assist the Bargaining Council and the CCMA with this question that they raised.
Thank you very much, Mr. Morrigan. I think what we need to understand is, and we need clarity before I can answer that, we need clarity from the CCMA as to their procedure when a rescission application is brought. The reason for my asking is, the rules are very clear, the match court, if we go to match court rules, that only an appeal stops the whole action. Once an appeal is filed, that attachment, for example, will also not lapse until the appeal is heard. But a rescission is still a process that will take place in the future. It is something that a date still needs to be set, whether it's an application for review, application for rescission. And once we've attached, the goods that are in storage or that have been attached are only attached for a limited period of 4 months in the match court. So my question here is when they ask the question referring to the review application, I'm trying to understand their question, because we are totally bound by the time periods that are set in the rules. And I'm just trying to think how to answer them. Just repeat that question to me so that I can just, it's on
Well,
the
the stakeholders wants to know when a rescission is in process, in other words, when a rescission application has been lodged, is the correct process then to reissue the enforcement, even if the enforcement period has not lapsed? Could the sheriff not wait for further instructions if the period has not lapsed? So in other words, what they are experiencing is certain sheriffs are obviously calling for a reissue of the enforcement award if the rescission application took a considerable amount of time to finalize, and it's gone over the 4-month period.
From my side, once the attachment is lapsed, that document needs to be reissued. It needs to be the rules are clear. It's only valid for 4 months. And once that is, because in the meantime, new costs have been incurred, whether it's the sheriff incurring costs, whether it's with goods in storage. So all those costs need to be brought into consideration when the 4 months has lapsed, so that when the new award is issued, that costs or those costs can be stipulated on the specific award to indicate what needs to be paid. I would personally, this is my personal opinion, in terms of a review that has taken place within the 4 months, and the goods are still under attachment, there's no need to reissue. There's no need to reissue it in the match court when it's a normal writ, because the attachment has already been completed. The goods remain under attachment for 4 months. The predicament we do have, though, is, and I know we're going to discuss this later on, is when it comes to the interpleader process. But that's a different kettle of fish. But me personally, I would, and I don't know if you agree with me, but I would say once the 4-month period has lapsed, we need to return that document to the CCMA so that they can amend the amounts and amend the claim amount, because suddenly there are sheriff costs incurred that need to be paid by the CCMA. And should that then be possible, with a reissue, the CCMA can at least recoup some money. But to come back to that, I don't spend too much time on this. My concern is that there's no way for us to pay money back to the CCMA that they've already paid on an account. I've posed this question. I was told that they do not do it. They do not receive funds into a bank account where they have, for example, settled a sheriff's account, for example, for the service of the award, for the execution of the award, and then later on there is a removal and a sale. Then the sheriff collects all the funds up to the date from his first process that was served. All those funds are paid, which funds are then paid to the applicant, which are not paid to the CCMA, because they do not have a facility in place to receive monies from the sheriff where costs have been recovered on their behalf as well. And that's a bit concerning for me.
Thank you, Mr. Burton. Thank you, Mr. Burton. You're 100% correct in the response of the lapsing time for the attachment, and obviously CCMA and the bargaining council needs to adhere to that. I just very quickly looked at the rules, the latest amendment, and I'm hoping that the CCMA and the National Bargaining Councils have looked at the amended rules 38 and 41, especially 41, Rule 41 of the Magistrates Court Act, obviously now governs the execution process of your enforcement awards. So my plea to you is have a look at these amendments. And a very clear sub-rule in Rule 41, and that is Rule 41.8c. And this goes to sheriffs as well. Sheriffs was listening on and was participating. And if you come across an instance where you received an appeal notice or an interpleader claim. Now, in the past, there was no clarity. It was a gray area as to what happens to the time period, the 4-month time period when a third-party claim has been received or an application for review or rescission has been lodged with the sheriff. Sheriffs were in doubt as to how to count, and the latest Mr. Burton, assists us now as sheriffs, and obviously the CCMA refers to rule and the bargaining CCMA to Rule 41.8c of the Magistrates Court Act. Clearly now that the attachment period will spend, in other words, it will stop. If for example, the sheriff made the attachment on the 1st of September and he received the third-party claim or an application for rescission on the 15th of September, that 15 days stops. In other words, doesn't start counting until the matter is finalized. In other words, clarifies the position in terms of the lapsing period and when it stops and when it continues counting. So to sheriffs, make note of Rule 41.8C, or 41.18C, sorry, and obviously to the CCMA as well and Bargaining Council. That is the response there. You pointed out, you picked up a very important point, Mr. Burton, and which CCMA could, I saw Mr. Morwa's hand up earlier on, is the issue of refunding fees to the CCMA, where you stated that it's difficult to make payments to the CCMA for costs covered. And CCMA did raise a question in regards to why is the sheriff not collecting the costs and recovering the costs. And I'm hoping that Mr. Boyson or Mr. Morwa can assist us as to how sheriffs can pay. And I did hear this before on the ground as well, where sheriffs attempted to make payment to the CCMA and they just failed. So it's very important to get a response from the CCMA, because there could be funds due to you and obviously you're not getting it, and you could help more people in this regard. Thank you, sir. Mr. Boyson or Mr. Morwa?
Thank you, sir. Look, we will relate on this. We will consult our internal colleagues within the finance department and then come back to address this. It should not be a problem, but just allow us to deal with it internally and revert in terms of a process. I'm not sure if you got my response.
You're a bit low there. I battled to hear you. If you could be a bit louder.
Oh yeah, I was just committing that we will revert on the issue after consulting some of our colleagues within the CCMA, like your finance department, who are responsible for money-related issues within the commission. So upon consulting them, we should return the feedback.
Yes, that would be important if you can send a circular to sheriffs, giving them the exact process to make. I have a question here from Mr. Tommy Tembe. He says, in the event that there is an enforcement award against a company and the sheriff finds that the defendant company has moved to another address, is the CCMA willing to change the address on the enforcement award to reflect the new address where the attachment has been made? I'll read the question out again. In the event that there is an enforcement award against a company and the sheriff finds that the defendant company has moved to another address, is the CCMA willing to change the address on the enforcement award to reflect the new address where the attachment has to be made?
Thank you. It wouldn't be proper to do so, because clearly if the respondent in that scenario never received the notice of set down and was obviously in default, not there, the proper thing is through a rescission to then rescind that original award and restart the process to have both parties there. For example, where there were both parties in the dispute which resulted in an award, and if there is an error on the part of the commissioner in describing detail of the respondent, that can be dealt with in easily by a variation of that particular award to correct whatever omission or error common to both parties that there were. Thank you.
Thank you, sir. Thank you. I got a note here, not a question, but just a note from Mr. ID Mohammed, who says that the CCMA should consider doing conducting a means test, and the sheriffs does not have the authority to be part of the payment dispute. I'm not understanding the statement very clearly, but I'm assuming that Mr. Mohammed is trying to assist in getting the CCMA to do a means test of the applicant or the National Bargaining Council rather, to do a means test of the applicant's ability to pay the fees or to finance the matter on his own, and says that the sheriff should not be party to the payment dispute between the National Bargaining Council and the applicant. Mr. Morwa, you want to come in? Your hands is up.
Oh yes, look, there are a few times where we are able to assist with the address issue, where we are satisfied that, look, proper process, has been effected, depending on the method of service that we may have used, during the service of the notices and stuff like that, because it depends on the method that may have been used at the issuing of the notice of set down. For example, that may not affect the fact that the notice may have reached, the respondent. So depending on such thing, yes, in certain instances, we do assist. I just thought I need to just throw the distinction. But of course, the case of the SC also applies, but dependent on the method of service that may have been used at the notice. So okay.
Thank you, sir. Thank you. Mr. Burton, I'm assuming these questions are being raised by a participant called Mpolelo. And from reading the questions this person is posing, is coming from within the stakeholders, NABC or CCMA. It seems like this person is an official. Firstly, the statement she makes or he makes is that they are finding that sheriffs are not collecting the costs of the CCMA or the applicant. And it's something that the profession must look into and advise sheriffs that it is their responsibility to ensure that when they're executing the enforcement awards, that they should ensure that the costs are collected from the respondents. Mr. Burton?
I agree with that, Mr. Murigan. Well, it is standard procedure in most of the sheriff's offices when they do calculate the awards or warrants or writs, that they include their costs as well as the deposits paid by the applicant for the execution of such process, so that they can get their costs back. It is worrying if the person who posed this question is correct, and I think it should be taken up with that specific sheriff. But it's very clear in terms of the calculation of the warrants that you must collect all costs, because they were also costs incurred by the applicant, if not costs paid by the bargaining council or by the National Bargaining Council or by the CCMA. And again, I don't know, in my office it doesn't happen. We collect those costs, and I'm sure in yours as well. So I don't think there's a lot of sheriffs that do it, but if it is something that that has started sticking out its head, then we need to curb that. And I think we can address that just by, we can take that up on the communication side of the board and see that we send out a short circular just to make them aware of that.
Thank you, sir. While I have you on screen, from Mpole as well, states that she should be advised. It's a long discussion she's got here in regards to fees, but the important aspect that I want to raise, she says that sheriffs should not insist on immediate removal, but rather should wait for instructions from the CCMA. Sheriffs should not insist on immediate removal when executing the enforcement award, but should wait for instructions from the CCMA.
Mr. Murigan, thank you. That is a very sensitive subject at this stage, because it's something that we've posed to the CCMA previously as sheriffs. My concern is who gives the removal instruction, the CCMA, or does the applicant do that? My second point is that I've not seen any rule that allows the CCMA individual who issued the award issue an immediate removal in terms of Rule 41. I think it's 18, it's changed, but I've never seen the CCMA issue an immediate removal. as it's very clear that only the clerk of the court can issue that upon submission of good reasons why it should be done. So I'm a bit concerned if sheriffs are asking for immediate removals from the CCMA, because it's something that I've never dealt with, or I saw a chat about it a few days ago, but it's not something that we find. And I do not believe the CCMA, because we fall under the rules of the marriage court, it is something that must be done by the clerk of the court upon satisfaction being given why an immediate removal should take place. But that, again, that is something that we need to discuss, because who does that? The CCMA, who goes to the clerk of the court, or who gets that authority, or the applicant? But immediate removals, I've not seen any of them come through the CCMA law.
I think it's a very important point for sheriffs to note that since the amendment to Rule 43 of the Labor Relations Act, the rules that one would follow to execute these enforcement awards is the Magistrates Court rules. And the Magistrates Court rules does not provide for immediate removal unless the applicant or the legal representative of the applicant has gone to court and requested, made application for immediate removal. So sheriffs who are requesting or insisting on immediate removal should reconsider their stance and obviously wait for the CCMA or communicate with the CCMA for the removal process, like instructing attorneys would do. Is when they are ready to remove, then they will instruct the sheriff. So just be cautious to the profession.
Mr. Morrigan, can I just ask a question, please? Just for clarity for us as sheriffs, or for the sheriffs that are part of the Zoom, who is the authority to give the removal instruction? Does it come directly from the CCMA, or does it come from the applicant who and is now acting on his own behalf? Because we do not receive removal instructions from the CCMA. It comes from the applicant. He completes a form. The necessary Rule 38 is completed by the CCMA, in my instance, by the CCMA, and then the removal takes place. But I hear that what is being said, that the CCMA should give the removal instruction. Do I understand that procedure is correct?
Okay, before I call on the stakeholders to respond, I want to raise the issue of the Rule 38. I've seen a number of questions raised on the Q&A, and as I said earlier on, I deliberately did not ask the question because I want dialogue with the relevant stakeholders. And obviously, we must walk away from this Zoom meeting with a proper directive. I'm hoping that is what we can do. Colleagues of the CCMA and National Bargaining Council, as you are aware that the amendments to the rules took effect recently to Rule 41 and 38. Now, I know since the amended rules took effect, there was confusion, especially from the side of the CCMA, in regards to whether they are responsible to provide the indemnity. I am aware, and I saw a number of questions posed on this Q&A where sheriffs are referring to the circular of the board and decisions taken by the board and the CCMA in regards to the CCMA furnishing an indemnity. I've also had discussions with my CCMA in Durban, and I'm sure many sheriffs in the relevant jurisdictions had discussions with the CCMA. I want to start by first asking the CCMA their view in regards to the instruction given to sheriffs for removals. Is it your responsibility or is it the applicant's responsibility? Because remember, when the instruction for removal is given to the sheriff, a whole lot of process takes effect from there. You get a sale taking place, you get advertising taking place, you get goods in storage taking place. There's a whole line of responsibility that the sheriff will have once that is given to the sheriff. And obviously related to that is the costs that's going to be incurred. And obviously we're not talking normal service fees, we're talking storage costs accumulating, you're talking removal costs, you're talking labor, you're talking transport. So your view, Mr. Boyson or Mr. Mawa, and the NABC can come in if they want, if they have some input on this matter, is your view firstly on the instructions of the removal. Do you give the instructions to removal, or is that the responsibility of the applicant?
Thank you.
Mr. Boyson or Mr. Marwa?
Yeah, look, we also have Mr. Dube here. He's also a panel member. Just don't forget him every time you mention this.
Oh, sorry, we'll remember Mr. Dube.
Yes. I think we touched on this issue earlier, that with us wanting to minimize and managing the cost in terms of the enforcement, we are saying don't remove until instructions are given. And normally we are able as CCMA to give the instructions, you know. We give the instructions to the sheriffs. As we have advised earlier, that in the event you are not able to recover those costs from the respondent, CCMA takes responsibility on those employees that fall within the threshold or below the threshold. Now, that's why then we then take the responsibility to give the instructions so that we are able to manage the cost on our part. And for reasons that we have already given, we have seen quite a success in that, in terms of management of cost and, of course, other related matters that comes with the enforcement, because some employers will call and want to settle or want to, you know, invoke some of their rights, such as 144.5. Thank you. I'm not sure if my colleagues would want to add.
Yeah, Mr. Dube, if you want to come in there.
I think the NSC has covered it. We give those we give the instruction. Some of the applicants that comes to the CCMA, they are lay persons. They don't have the expertise to deal with such issues. So we do assist them well within the threshold that is set.
Okay, thank you, sir. Colleagues, I want to raise the issue of, before I get to Rule 38, I want to raise the issue of interpleader hearings or third-party claims while you're online, Mr. Dube. Obviously, we are aware that the CCMA will not attend to third-party claims. In other words, the payment of the sheriff's fees or providing the sheriff with instructions. Is that still your view in regards to the CCMA not taking responsibility for the third-party claims? Because it's still a very, very huge problem for sheriffs at the moment, because sheriffs are stuck with informing the applicants correctly as to what the next step is, because there is this issue of certain courts in certain provinces who are willing to attend to the interpleader hearing on an enforcement award. Certain magistrates courts are willing to do that. Certain magistrates courts in other provinces are not willing to attend to this matter. So sheriffs are stuck in between, where the applicant is constantly calling to his office, or sometimes the sheriffs are reported to the South African Board for Sheriffs for misconduct because he is refusing or he does not want to proceed with the process. Now, obviously the sheriffs work strictly in regards to rules. He has no discretion in the magistrate's court when enforcing the rules. He has to follow the rules very strictly. So if his mandator is instructing him that we are not taking responsibility for the fees or for giving you instructions to proceed with a third-party claim, he obviously has to stop and think what he has to do. And more importantly, the relevant courts that he serves under will not hear the matter. So it's something that is really stagnating the whole enforcement process. And remember, you are paying us fees to do the attachment and sometimes the removal. And these goods are held in storage, whether it's an application for rescission, whether it's a third-party claim. Goods are already in storage, you got a third-party claim. And obviously the sheriff is incurring storage costs. Sometimes sheriffs outsource their storage, so they have to pay a service provider. Those goods are lying in storage endlessly. And he's not getting any response for the CCMA. He can't go unilaterally issue the interpleader summons on his own accord, because the rules provide for him to notify his mandator, and the mandator must respond within 10 days, and then only proceed with the interpleader. The rules also provide for him to proceed to issue the interpleader claim if the mandator does not respond. But who bears the cost for this? If you can assist us on your latest view in regards to the third-party claims, sir. Has there been any change since your last since the last discussion with the profession?
No, there has not been any change. We don't get involved in interpreter processes, unfortunately.
So what happens to the sheriff and the applicant? How do we handle it? Can you direct us? Can you give us some guidance? How do we handle
normally we will refer applicants for pro bono services where they can get them, like your law clinic, to assist them, because they may not have the knowledge and the idea what this involves, and the pro bono services will then come handy, you know, under such circumstances. But unfortunately, CCMA does not get involved in the interpreter processes.
Mr. Morrigan?
Yes, sir. Coming.
If I may, just on the point of the pro bono services, the concern that I have, or that we have, is the fact that the moment we refer the matter via the applicant to the pro bono service or legal aid, it takes months for us to get feedback. But I can also, in the same sentence, say that I have had a meeting with both senior magistrates at Palm Ridge as well as Johannesburg Central, and both of those courts are willing to hear the interpreters, because it's not a judgment that needs to be granted, or the magistrate purely just needs to decide on ownership. He doesn't need insight in how the matter was brought before the court, what happened about the award. He doesn't need to give any input or judgment in terms of what has already happened. He only gives the outcome of the interpreter. And we have tried this once or twice successfully, where the applicants had the funds to pay. We explained to them what the costs are as per Table C Part 2 that can be charged for the filing of an interpleader, and those documents have gone to court, and we have filed on their behalf. And on all three instances, the court gave a ruling on ownership. So the magistrate courts are prepared to do it. The crux of the matter is you need to involve the correct individual at court, and not to go to the clerk of the court only, because it's not the clerk of the court hearing the interpleader. There's a section for that. And as the magistrates clearly stated to us, that we are bringing that application, that summons, we are drafting those documents. Therefore, the magistrate court can hear it. We are sheriffs, if I refer to we. So I think it's also very important that colleagues approach their local court and say, this is the instances, this is purely interpleader that needs to be heard as per normal under the reference number of the CCMA. And well, we've succeeded successfully with 3, some not, but those where clients were able to pay the fees as regulated, we proceeded. Thank you, Mr.
Thank you, sir. While you're on screen, I know I can see our deputy chairperson of the board's hand is up, but before I get to her, I'm assuming this person is from one of the stakeholders, Bongo Musa, states that she needs or he needs assistance from us in regards to sheriffs demanding double payment for his fees. In other words, upon the undertaking that the CCMA will settle the sheriff's costs, the sheriff still insists that the applicant pays the cost upfront. What is your view? How can we advise sheriffs on this? In other words, the sheriff is not accepting the CCMA letter. He wants his fees upfront from the applicant.
Yeah, it's a prickly pear, that one, with a lot of thorns, because I can understand where sheriffs are battling to get payments. I can understand where and why they are doing it and where they're coming from, especially where certain accounts are overdue. And I'm not going to say just CCMA, it reflects to all stakeholders that make use of the sheriffs. And we all know that if we run 30 days, so if the account gets to 120, 90, is it fair for the sheriff to still proceed, or is it reasonable without having his previous accounts paid? So we need to understand the situation, why the sheriff is expecting an upfront payment, which will then be refunded once the CCMA pays the account. But in the instances where the accounts are up to date and we do not have issues, it is standard procedure for the sheriff to bill the CCMA and not the applicant. Because the applicant might be a man of straw. He might have nothing. And he's used his last money to get to your office to bring the award that was awarded to him by the CCMA. He's been unemployed for 6 months. So there's no way he can pay for it. So but
your
that's
point
just
being,
my
your
point
point
being,
being CCMA should look at payment of sharers fees in order to ensure that the applicant is not turned away.
correct. Thank you, Mr.
I'm going to give Mrs. Titus
Yeah.
an opportunity. Amanda.
Oh, sorry.
Okay, thank you, Mr. Murugan. I just want to refer back to Mr. Burton's issue regarding the interpleaders. Unfortunately, Mr. Burton, there's no uniformity amongst the courts, and in Cape Town, they refuse to do interpleaders. So according to them, they don't have jurisdiction over CCMA matters. So you're lucky that on your side, your magistrates, will entertain interpleaders, but unfortunately, in Cape. So can you hear me?
Yes, we can. Yes.
Oh, okay. Sorry, I see, Alan, your lips is moving, so I thought. Okay.
Sorry.
Okay. Now, perfect. Yeah, there's just one point that I want to raise. There's no uniformity in the courts, where, like, in the one jurisdiction, they will listen to, they will adhere to the interpleaders, but on the other hand side, the other courts, they refuse to entertain. Thank you.
Thank you. Mr. Morwa. You want to come in, sir?
Yeah, thank you, sir. Look, I just wanted to advise that in the event where, for whatever reason, the sheriff would want upfront payment or would demand the payment from the applicant due to CCMA having not settled some of their account, can you, on the list that SC Boysen is going to give you, you will get the contacts, and please get hold of those people. Let's, work together on this, because it really puts a burden on these applicants, poor applicants that we all are here to assist. So yeah, let's help each other. Thanks.
Okay. Thank you, sir.
Thank you. Mr.
Colleagues, yes, Mr. Burton.
Sorry, something that has come up now in the last few weeks regarding payments, where large machinery of companies have been attached in terms of the awards, or trucks or cars or vehicles. We have to pay those disbursements for those vehicles when they are removed up front. We do not have accounts with the various breakdown services and transport companies. So those are costs that need to be paid upfront. If the profession can just get clarity from the CCMA as to who's going to be held liable for that, because sometimes you find that the company might not have a lot of office furniture, but the claim might be 100,000 Rand for 7 different applicants in total, but they do have 1 or 2 trucks. Now those trucks need to be moved, put into storage, whether it's towed or whether it's driven, and we have disbursements up front. So can I just clarify that those costs are costs that will then be paid by the applicant and not the CCMA? If we can just clarify that.
Okay, thank you.
Yeah, well, remember what we're saying is that the applicant qualifies for assistance in terms of the threshold. And obviously, we also saying the applicant may not be able to afford, and putting a burden to him will be defeating the very intention that, we are assisting them. Hence, we are saying, look, raise issues with us, but of course, for CCMA, once we get the invoice, we have 30 days within which to pay. Yeah, I think for us, once the person qualifies, it suggests that this person, needs the assistance, and as far as possible, this person must get the assistance. And the issue of payments can be addressed either yes, later, probably, for example, where you may not have recovered the cost, or if you have recovered the cost later in the commitment that we have made, monies can be paid back to the CCMA.
Thank you, sir. Thank you
sir.
for your response. This is just certain points I want to raise before I go to the Rule 38. First point was raised where Mr. Mohammed says that if the relevant stakeholders, the NABC, the South African Board for Sheriffs, and the CCMA can flight the Labor Relations Act on your websites, so individuals can see, can read or understand the Labor Relations Act, especially the amendments that we're referring to. So that's one suggestion is made, that you'll place the Labor Relations Act in your relevant websites, so sheriffs can obviously find it on the Board for Sheriffs website, and applicants can see it on the CCMA website. Another to the NABC, Maggie, if you're still available there. We haven't discussed the interpleader proceedings that relates to the National Bargaining Council and how do we address this issue. As a similar situation, as the CCMA clearly pointed out that they will not be party to the interpleader proceedings. In your case, what is your understanding of your responsibility in terms of third-party claims? Now, we are aware that there are certain instances where the National Bargaining Council will access the I-Court, the Labour Court, in regards to issuing writs through the Labour Court on behalf of the applicants, and sometimes you access the CCMA to issue the enforcement awards. Now, in regards to the Labour Court matters, Maggie, in practice, when the sheriff follows the I-Court rules in the execution process, same would apply to your writs that you would issue out of the Labour Court, because the Labour Court follows the I-Court rules. Now, in practice, the sheriff would obviously engage the applicant's attorney to obviously go to court and represent him as the applicant, and obviously inform the sheriff of the outcome of the interpleader. Or in some cases, the sheriff would engage an attorney to take on the matter and take the matter before court and obviously advise him of the outcome. And obviously, if the sheriff engages an attorney, it's a very, very costly process. You're engaging an individual, an independent attorney to hear a matter, and obviously he's going to give the rates that he would charge an ordinary person. So we found over the years that that process is a very not a very cost-effective procedure, and we normally would hand it over to the applicant's attorney to go to court and finalize. We found in practice that the bargaining council's legal representatives are very reluctant to represent the applicants in the interpleader hearing. What are your views, ma'am?
Okay, bodies are here. We actually do not get involved in interpleader proceedings. We would only do so if the funds that are to be recovered would be beneficial to the bargaining councils. If the matter revolves any costs that are to be recovered by the bargaining councils, by all means. But if it is for the applicants, we unfortunately do not have the resources to assist them beyond issuing of the awards.
Okay, so your stance as well.
That is the case with all bargaining councils.
So in other words, are you saying that the sheriff needs to engage a law firm to assist with the interpleader proceedings on behalf of the applicant?
Yes, and those costs will be borne by the applicant themselves and not by the bargaining councils.
You see, this we hear you very loud and clearly, and I'm glad that you clarifying your position. Our difficulty is that we now have the applicant in our offices, and to stand there and tell him he needs to pay 40,000 rands legal fees to take this matter before court, it's actually travesty to justice. I'm not sure how between the CCMA and the National Bargaining Councils and maybe the South African Board for Sheriffs can thrash this matter out and find some sort of common ground or some sort of direction for the applicant and the sheriff. Because remember, you know, the public out there is so aware of different ways and means to avoid taking responsibility of the debt. And it's so simple just to give the sheriff an affidavit. And sheriffs and deputy sheriffs work in these areas day in and day out. And sometimes they might know that, hang on, this respondent is lying. The goods does belong to the company. But as you know, the sheriff is an officer of the court, an impartial third party, and he is not there to adjudicate over these matters. So he cannot make a unilateral decision. And it leaves us in a predicament where we are unable to direct the applicant, or we have a very despondent person in our office. And in most cases, they start a huge fight in the office of the sheriff. And in some cases, the matter is referred to the board and the sheriff is taken on a long disciplinary inquiry, not realizing that the sheriff's hands are tied. There's nothing he can do because CCMA doesn't want to take responsibility for reasons you only obviously you have, and obviously now the NABC would not take responsibility. What happens to the sheriff in this case and the applicant?
Yeah, I suppose it's a good question that can be canvassed in the next meeting. At this point in time, we do not have we do not have answers. It's something that we because I hear Burwa refer to pro bono services. Perhaps that is the route that we need to canvass. Yes, I'm not so sure if we'll be able to exhaust that subject matter in this meeting, but that is our stance, and it is guided by practice.
I think what's very important, it is a very, as I elaborated just now, it's a very important aspect that needs to be considered by all stakeholders, because sheriff's officers of the court, CCMA is responsible party to the official to guide these applicants, and obviously you as the bargaining council, and obviously, as I said, the sheriff has very little authority in determining what happens. Maybe a suggestion from the profession is that stakeholders approach the Minister of Labor and the Minister of Justice and see how best the rules can be amended and what systems can be put in place. Maybe a meeting with the National, the Magistrates Commission to give direction to the magistrates as to how they hear these matters. Because generally, if a matter is given to a sheriff from a court outside his jurisdiction, he would take that matter, because his magistrate's court is within his jurisdiction, to his local court, and the local court will hear the matter, although they didn't pass judgment on that, didn't grant the judgment. Now we feel that system could be used in the case of the interpleader process, like Mr. Burton pointed out earlier on in the Gauteng Magistrates Court. The magistrates undertook to assist in that manner. So maybe very urgently, in fact, that the CCMA and the bargaining council can try and engage the relevant ministers to assist us. I'm going to give Mr. Dube an opportunity very quickly. We got 15 minutes, but I want to get to Rule 38.
Yeah. No, thanks, Chair. I think I agree with you that maybe an engagement on this issue of interpleader with relevant stakeholders must take place, but also with the storage, because I think most of the cost, that's where they come from. And in an ideal world, I would suggest that we should find a way where maybe the councils and the CCMA have a certain rate with the sheriffs in trying to assist the applicants, because truth be told, most of the expenses that comes to the CCMA, it comes as a result of the removal and the storage.
Okay. Further engagement will take effect. Colleagues, I want to get to, we got 15 minutes, and the most important aspect that we need to address is the rule. Mr. Dubas, remain online. The Rule 38, providing the indemnity to the sheriff. As I said, there's 35 questions raised, and I'm sure half of those questions related to the Rule 38 and the interpleader. Rule 38, as of late, due to the amendments of Rule 41 and 38, CCMA took a stance that they do not have to provide the Rule 38 indemnity. The sheriff's profession, on the other hand, says, no, hang on, you have to provide the Rule 38 indemnity. Now, we are not sure what is the CCMA, what are you relying on to justify that you do not have to give the indemnity. If you can assist us understand your view as to why you feel that you should not give us the indemnity, supply the sheriff with the indemnity.
Thank you, sir. Yeah, look, In fact, there is a note from the RSC or the commissioner of the CCMA where she is actually helping with the question, because we got a circular or a memo in which you were committing that, look, there's been a change to Rule 38 on indemnity in that it will only be required where there is an. And as the CCMA, we're not involved in the indemnity, and that's why we are not able to give the indemnity. And we are a bit confused by this question, especially from yourself, having engaged you and having got the circular or the memo from yourself, giving us that direction. And we are not clear as to, you know, what changed, what happened to that circular, and why are we having the discussion once again on something that we thought it's now settled? Because that's how we operate now. And in fact, in the commitment that was made in the circular is that, or during our meeting, is that where there are issues with some of the sheriffs still demanding indemnity, we must give them that so that they can see, you know, the state of affairs on the issue of indemnity. So, yeah, I think it's a question coming from both sides. You have a question to ask, but we also say, but what happened to the circular of the memo that was issued out on this? Unless, you know, we miss something, but our understanding is that indemnity is no longer a requirement unless there is an interpreter, and an interpreter, it's not something for CCMA. Thank you.
Okay, thank you, sir. I hear you. I hear you, but I want to bring in Mr. Burton. Before I get into Rule 38, reading out the actual rule, I want to bring in Mr. Burton just to give us some overview of the board's view on this matter. Or if you can assist us, answer your question.
Let me see if I can assist. Thank you, Mr. Morrigan.
I'm putting you on the spot, Mr. Burton.
Yeah, I'll handle it. I'll try and swim. Thank you very much. To come back to the Rule 38, the circular that was provided to sheriffs was purely an informative circular to inform them of the changes of the rule. Yet we cannot just focus on Rule 38.1, for example, in terms of the rules. Rule 38 does not consist of Rule 1 only, or point 1. It consists of point 2 as well, with a lot of subsections under that rule. And just to go to the last point of Rule 38, in terms of the amendments, the only party that is absolved from providing Rule 38, as per Rule 38.5, is the Legal Aid Services of South Africa. It's the Legal Aid South Africa. They are the only party that is not required to provide security. Now, in context, I understand why the circular was read and understood as it was in terms of what was provided, but if you go and look at the context of the specific rule which we can distribute to the CCMA, should it be necessary, as it was gazetted, we need to understand that it says that we cannot, the sheriff, I'm going to use an example, the sheriff cannot, should not, or cannot request security if the process that initialized the removal or the warrant was served personally. For the CCMA, we serve no other documents except the award. We execute the award. So in terms of that, we are already in our rights to ask for indemnity as a sheriff, because we had no preliminary action to this. We did not serve the document. We weren't party of the action or to the action. We served nothing on behalf of the CCMA. And Rule 38.2 is very clear. Unless the summons commencing action has been served upon the defendant personally. And we serve nothing. We execute the award once the applicant brings it into our office. That is but one of the points in Rule 38. And then obviously point 5. The concern is, though, that the rules are very clear. The sheriff must have security in his possession prior to the sale of execution, which means we are still going to demand from the CCMA, should they go as far as giving removal instructions, and the sheriff will have to sell, the CCMA is still liable for the Rule 38 prior to the sale. And there's a time limit as well. I think it refers to 10 days prior to a sale taking place. Rule 38 must, 10 days before the date of sale. The CCMA should, or the instructing party should then provide the sheriff with indemnity or Rule 38. And to go one step further, the Rule 38 is a preliminary requirement from our PI insurer on all warrants or actions that we take, where we might think there is going to be a legal claim or a counterclaim, because we do not know what's going to happen in the future. But the predicament still lies that the sheriff enters premises of an individual who feels that the sheriff did so illegally, although it was issued by a clerk of the court or a registrar or the CCMA commissioner. Those documents were issued, giving us the legal authority to do so. And yet 2 or 3 months down the line, that individual has approached an attorney who has seen a chance to make some money and then sues the sheriff. And the first thing the insurer, the PI insurer, asks is, did you have indemnity? Did you have security? Those are but some of the points. But again, Mr. Morrigan, I think we should read the Rule 38 in its context as a whole, and not just select certain portions of Rule 38 to clarify our points. Thank you, sir.
Thank you. I just want to add to that. I think the circular issued to the profession, and the circular that is being relied upon by the CCMA does not cover Rule 38.2. It stops short of Rule 38.2. It only covers Rule 38.1. Now, CCMA is correct in saying that they will not give indemnity to make the attachment. But the rule clearly states that if there is a third-party claim and the removal still has to be done, then yes, CCMA in terms of Rule 38.1 must provide the indemnity. But I think where the confusion is coming is when the CCMA now requires, or the applicant now requires, the sheriff to proceed with the sale. Now, Rule 38.2 is what we want to bring to the attention of the CCMA, is that you need to not look at Rule 31 only, which is part of the circular that you receive from the South African Board for Sheriffs. You need to go further on and look at Rule 38.2 as well, which specifically states that upon instructions given to the sheriff to proceed with removal and sale and execution, the execution creditor must indemnify the sheriff. Now, where, in my view, as a practicing sheriff and somebody who understands the various processes, and I'm also in my response now going to refer to Peter V, and I'm assuming he's from one of the stakeholders, where he says the Treasury has instructed the CCMA not to enter into indemnities. How do sheriffs assist other government departments and parastatals? That is where the problem of the CCMA arises, is that you are not protected, or you should ask yourself whether you're protected by the State Liability Act. Certain parastatals, certain government departments are protected by the State Liability Act. In that way, referring to, for example, the state attorney. State attorney does not give sheriffs indemnities because they're protected under certain acts. In the legal aid, until these amendments took effect, legal aid was not protected by any act. They had to give the sheriff an indemnity, and they made various submissions to the Rules Board, to the Justice Department, and extensively, I'm aware that they fought for over 4 or 5 years to be excluded from providing indemnity to sheriffs. And only through these amendments, they now are excluded from providing indemnity. I'm not sure on what grounds they are excluded, whether they now form part of a certain act, example, the State Liability Act or Chapter 9 institution or whatever institution that they now fall under in order for them not to provide the indemnity. So this is where the problem lies with the CCMA. Until such time that you can prove to sheriffs that you are protected under a certain act, the sheriffs will insist for indemnity, because to us, you are an ordinary execution creditor's representative. You are our legal, you are the legal instructor for the applicant. So you are in no way protected, put it that way. You need to supply the indemnity in terms of Rule 38 to the 38.2 to the sheriff. And the unfortunate situation is that since the circular came out, or since the amendment to the rules to now, a lot of attachments have already lapsed, because sheriffs are enforcing Rule 38.2C, I think, or B, where it specifically states that should the execution creditor or, well, legal representative does not furnish the sheriff with an indemnity within 4 months, that attachment lapses. So what happens? The cost that you paid the sheriff to do the attachment and what have you, the action of the sheriff, and you paid the sheriff, and the fact that the sheriff is not getting the indemnity is lost when the attachment lapses. Now the process has to start all over again. Now try explaining this to the applicant, a layman on the street. It's very difficult. So I think the aim of the profession, firstly, we are aware of the circular, which should have explained Rule 38 to you. We are saying the important point was raised in terms of Rule 38.1. And individual sheriffs, as Mr. Burton has pointed out, have a legal issue with the matter in the sense that their insurance or the indemnity cover is at risk if they are not protected. Because if a sheriff proceeds and executes, do the removal, hold the sale on something that creates doubt where there was doubt because the sheriff was not part of the entire process, and he is being sued for damages, his insurer will not cover him. That is our predicament as the sheriff's profession. And that is where we are saying to you, you need to look into this matter and inform the sheriffs under what legislation you are protected by not complying with Rule 38.2. Then the sheriff's profession can look at it. I'm talking as a sheriff and giving you this advice as a way forward, basically. And obviously the South African Board for Sheriffs through Mr. Ian Burton can further elaborate and obviously identify ways and means through discussions with the insurer and yourself as to how you can overcome this predicament. But until there is a solution, tangible solution to the problem, you are required to comply with Rule 38.2 as an ordinary execution creditor's legal representative. As I mentioned earlier on, the Legal Aid Board fought for over 4 or 5 years to be excluded. We are not sure legally what you can do to exclude yourself. Mr. Morwa, you want to come in? Mr. Boyson, you want to come in?
Yeah, well, quite disappointing on our part because we thought this matter is now resolved for our users, particularly the vulnerable, and it would appear that, you know, we're back to square one. We hear you. We just ask you to be patient for now because we were relying on your very secular, and we thought the matter is now settled. So we may have to probably look into the matter afresh and look at other avenues in how best to deal with the matter, because when we came to you, we were really quite at pains because we are worried about the vulnerable, the purpose for which administrative action is embedded, you know, in dispute resolution. Now, if we are going to have this kind of challenges, this may interfere with the very purpose and may really take us a bit back. So yeah, quite disappointed, Mr. Murugan. We thought the secular settled the matter, and there was no point also that the secular was either clarified or withdrawn to put that which you are put in today. It's only today, for example, that we get to hear that, you know, the secular should have gone beyond Rule 38.1, maybe to Rule 38.2 and others. We didn't know that. And, yeah, it's quite disappointing. But let's try and see, for example, what we can do with your advices, like the example of State Liability Act. You know, I don't know if there's anything that we can do. I'm not promising anything. I'm just saying we'll have to, you know, talk as an institution and see what is really doable and revert on the matter. But we're just asking for your patience in the way that you are working now, for example, where you don't see any danger and stuff like that, to please continue to assist the most vulnerable that we are here to assist. Thanks.
Thank you, sir. I'm sure the profession is hearing you, and
Yeah, I don't know if it's only myself, but we can't hear you, Mr. Morgan.
Sorry, we also lost there. We didn't hear the last part, Mr. Murray.
Yeah.
We may have lost his feed.
While we're waiting for Mr. Murigan to come back, my apologies. Just to clarify a point, it's not security. The security requires normally required or requested upon the removal instruction. So the initial part of the attachment will proceed as normal, as we do normal warrants, as we execute the normal writs. But it's mainly when it comes to the removal instruction, which is good to know will be coming from the CCMA, because I think it's imperative that when the removal, prior to giving the removal instruction, the individual who is going to make that decision to say, okay, the sheriff must proceed and remove, should familiarize himself specifically with the attachment, the inventory that was made, so that they are aware of what will be removed. Because if they look at a list, I saw a question earlier on was where some people say, why do removal costs differ from sheriff to sheriff? It all depends on what was attached. We can attach a TV and a lounge suite, and that can be taken, fair enough, and it will cost X amount. But then you can have a 3-story house or a business that runs a factory where other goods have been attached, that the removal would differ far from just removing a TV and a lounge suite. So it will be good if the individual who is going to authorize the removal or give the removal instruction also familiarizes himself with the content that is going to be removed, because it is a little bit difficult to get everything in storage, and then it's a whole store full of stuff, and you get the question is posed, but why did you charge so much? But that will purely be up to this to the CCMA, or the individual will be giving that instruction. But thank you very much, Mr. Slach. I appreciate it. Mr. Murigan, I see Mr. Nell has just sent me a message. It looks like we've lost Mr. Murigan. And Mr. Murigan had to let me go to his listing in terms of security. Some questions that were posed as well is, let me just go back. I see we haven't had a lot of questions lately for the National Bargaining Council, so they are enjoying the discussion here, I hope. I know some sheriffs have some of the questions in the Q&A specifically addressed to the CCMA refers to pro forma invoices that are being issued, and I see there was a response, and then it says that pro forma invoices before providing service. I think that is something that we've clarified that earlier on, in terms of we'll be giving the instructions, and especially we'll be paying for an upfront payment should it be necessary. You have clarified that for us. Thank you very much. Just give me one moment. I was not monitoring. Mr. Murigan was monitoring the questions. Then one of the points, we'll get back to Rule 38 and the Rule 45 indemnity when Mr. Murigan is back. But one of the points that was raised in terms of the CCMA from Mr. Ashraf Dawood, also a practicing sheriff, is the fact that they receive awards where the award says Mr. Burton plus 10 others, but the 10 others are not mentioned. And then when the sheriff receives payment on that, how does he distribute the funds proportionally between the 9 others if he doesn't know who they are? Because they are not mentioned in the. We actually had one a week or two ago. We did get hold of the CCMA, and we were given a list of the 7 others that were mentioned. But if it is possible, just to add the list of the applicants, so that the sheriff is aware of who the distribution should take place to, because you do find the 1 or 2 individuals will say, no, pay it all to me, I'll distribute. They are my friends, and we need to prevent that. So, because my friends might be my friends today, but they'll be my enemies tomorrow if I pay out the 100,000 rand we were supposed to distribute. And that's just a point of interest. I also had a question here with wording on the CCMA awards, where it says that the sheriff may attach. It doesn't refer to specifically removal of goods, but I think we need to be aware, and this is to the profession, I think we need to be aware that the attachment process is part of Rule 41. It starts as an attachment, and then the rules make provision for the process to follow. So once the CCMA gives the removal instruction, that is part of Rule 41, just a different rule or sub-rule that allows for the removal process. So I think that we don't need to answer. And I'm sorry for this inconvenience now. I don't see Mr. Murigan coming back. I haven't seen him back on the platform yet. So please just bear with me. I just want to go through the Q&A quickly so that I can just familiarize myself with some of the questions quickly, if you don't mind. There's a question in terms of the CCMA awards raised. I can unfortunately not see who it is. There's no name. With the CCMA awards referring to interest amounts on CCMA awards. Now, in terms of and I'm not sure if Mr. Dube would like to come in and just maybe give some guidance, whether the CCMA, I know it's not mentioned in your award as such, but do the CCMA require interest to be paid on arrear payments? And if you have an opinion, I would love to hear that, and then I'll just give my own opinion as well once Mr. Dube has answered that question. Thank you, sir.
So, Mr. Patton, can you repeat? I lost you there.
No, sorry about that. No, it's regarding the collection of interest on amounts that are mentioned in the awards, because the award as such does not refer to interest. You will find that, for example, if we get a National Bargaining Council award or writ or warrant, they will refer to certain aspects in terms of interest, but the CCMA doesn't. And I would just like to hear your opinion on the collection of interest on CCMA.
Look, in terms of our practice, the commissioners should include the interest, that failure to pay this amount by the state interest to start re-incurring. And I think maybe on our part, it's also to sensitize commissioners to include that part in their awards, because if it's not mentioned, then it becomes a problem. I'm not sure if the SC or NSC wants to come in on this one.
Thank you very much. Yes, if somebody
I agree fully with you, RSC. Thank you.
Okay. From my side, just in terms of the profession, to my colleagues, in the Magistrate Court Act, it's very clear that should interest not be stipulated on a writ, the sheriff is, when doing his calculation and doing his collection, when payment is received, and that was legislation in 2020. I know it's changed a bit because the interest rate has changed. So we just need to check what the new interest rate for the courts are, the minimum or maximum rate. I know in 2020 it was 7% plus about 3.5 above that primary rate that was allowed by court. So if no interest was mentioned in a writ, if it was left out, the sheriff had to collect, for example, 7% plus the 3.5% above and beyond that on the amount that he is collecting in terms of the calculation on the writ and the settlement thereof. But if the CCMA can sensitize these commissioners to say that interest must be charged at the current prime rate, it will make it so much easier, because currently I'm sure there are very few sheriffs that are charging interest because it's not mentioned in the writ or in the award. And this is just an observation from my side. Mr. Murigan, welcome back. I see you're on a mobile device.
Thank you, Mr. Burton. It was hit with load shedding for the first time in 6 months. So yeah, we're in load because I'm on the cell phone and it's difficult to pick. So if you don't mind.
If I can suggest, so I know we don't want you to be put off your screen, your video, but I think for the sake of connectivity, if you can maybe just put off your screen.
All right, thank you.
So Mr. Morrigan, we've just touched on one or two points in the Q&A section of the session, where certain questions were asked in terms of interest to be charged on collections of awards, and we have received clarity from Mr. Dube and from Mr. Setlaku regarding same. So if you want to proceed, I would appreciate it. Thank you, sir.
Mr. Burton, I cannot see the questions now. As I said, I'm on my cell phone, so it's a bit difficult for me to field the questions. If you don't mind fielding the questions, and I can assist you.
Can we, before we proceed, can we just confirm that we are going to step off the Rule 38 discussion? And I think if we've got all the contact details of the various stakeholders here, we can forward the Gazette to them, and maybe just compare the Gazette to the circular that went out via the board's office, so that we can just get clarity on that, and that will also give them guidance as to how to approach the security and Rule 38 issue. But as I mentioned, Mr. Morrigan, we normally, as sheriffs, request the indemnity or Rule 38 security at the stage when removal is going to take place. And it's not normal unless there are circumstances that we are being prevented entry and things like that, where we would ask security or Rule 38 during the attachment process. It will only, in those instances, the sheriff would then be able to give reasons why he requested immediately, whether it's a hostile place that is going to, whether the people don't want him to enter. There are many reasons why it could happen. But can we step down from the Rule 38 until we could just get clarity between the different stakeholders, and then we can give feedback to the profession via the board's communications department, if that's fine with everybody?
I agree with you. I agree that the board should deal with the matter with the relevant stakeholders and give direction. As Mr. Malwa requested for time to engage on the matter and obviously revert. So I would suggest that as a matter of urgency, the board and CCMA engage on the matter and come up with a directive to sheriffs.
Thank you very much. I think we've covered, Mr. Morrigan, I think we've covered a lot of the questions in the list that was provided, and because a lot of it actually circled around or focused around the Rule 38 now, which we've spent quite some time on. If there are any other questions on that list that you have before you that you would like to raise before, I think we should then go to the Q&A, and I will, if you can't see it, I will gladly start reading out some of the questions, because one of the questions that we didn't get to in that list is when a locksmith needs to be used to open a premises, who gives that authority? And because you and I know when we receive the Rule 38 from an instructing attorney, once we've indicated that we can't gain entry, they will provide us with the Rule 38 security and give us instruction to make use of a locksmith purely for the attachment process. But when it comes to the removal process, again, it's a disbursement that needs to be, that takes place where the sheriff opens the property to remove the goods. Would the CCMA want us firstly to get instructions or clarity from them before the use of a locksmith? Because the predicament I see is once they've issued the removal instruction, the discretion now lies with the sheriff, because the rules allow him to open any door of any premises or of any object to gain entry. So that is just a question to the CCMA, how they would like to approach the use of locksmith services in the execution of their processes.
I think, Mr. Burton, before the CCMA comes in, I think it's important to understand that this issue can only be answered once we satisfy the issue of the indemnity, because it largely depends on the indemnity issue before using a locksmith. So that is where part of the risk comes in when a sheriff opens the door and he is now in trouble because he opened, the respondent got some claim or some parties got some claim against the sheriff. So I think that question can be properly answered once we have a directive from the engagement between the board and the CCMA regarding the indemnity issue. In regards to the instruction, I'm sure the CCMA, I'm saying it again, I've said it before, over the past 2 years or 3 years since our last engagement with the different deputy ministers, we have seen an improvement in the communication between the CCMA and the sheriff. But the essence of this meeting is to improve on that communication. And I think for sheriffs as well, we need to impress upon them to start engaging more effectively with the CCMA. We generally establish relations with the relevant departments of any practice that of any firms that we practice with. For example, with attorneys, we'll establish an immovable clerk relationship with the immovable clerks in the relevant attorney's office or the movable clerks. So we need to, as much as we are emphasizing to the CCMA and the NABC to foster better relationships with us, we need the profession as well to start engaging relevant people within the CCMA and the NABC and start. Largely, my point being, we need because the rules that we follow, we want to follow sub rules. So I think we need to do a lot of educating between ourselves in order to resolve a lot of these problems. A lot of these questions I've been fielding from inception today is issues that are practical issues that can be resolved through proper dialogue. So I want to encourage the profession as well to start engaging more effectively with their relevant CCMA officers. Like you mentioned, you to went the extra mile in engaging the relevant magistrates within your jurisdiction to see how best you can find solutions. So as much as we're leaving certain aspects to the CCMA to come back to us, I think we as a profession must commit to engaging more effectively as well with the CCMA. I know there's a lot of problems in regards to paying of fees, in regards to now the Rule 38, but I think let's walk away from this engagement where we foster better relationships for the benefit of these litigants, rather than these litigants, because of the technicalities of the rules, these litigants are left walking away empty-handed. Mr. Marwa, you want to come in there?
Yes, first, thank you really for your comments. Quite positive, and I'm really happy with the advices you're giving to us here stakeholders. I'm quite excited about it because that will improve our relationship, but also go the extra mile in helping the most vulnerable that we are here to assist. I'm not sure, given your advice in terms of the locksmith, if you would still need me to answer the question, because like you said, it has to do also with indemnity, and indemnity is still an issue given our discussion today. I'm not sure if you will still expect me to answer that.
To a large extent, I'm trying not to mislead sheriffs or your relevant officials. I think what's most important is for us to resolve the Rule 38 issue, and obviously, reality is that because there's no solution to the Rule 38 matter, the sheriffs are at limbo at the moment. As I speak, I know I'm a practicing sheriff. I know what more or less running in many sheriffs' heads as this conversation continues is they are not giving us an answer. What do we do with the files in my office now? When I get off this the Zoom meeting. What do? I don't have an answer. So I'm saying the issue of the locksmith, I believe that should be addressed through the Rule 38. And I'm hoping through this conversation today, the board and yourself can sit and draft a proper circular to sheriffs and obviously your relevant officers, giving proper guidance in terms of your instructions. There's lots of things that was raised for the NABC to take into account, for you to take into account, and for us as a profession to take into account. What I'm hoping to achieve out of this conversation is that the board, obviously this conversation is recorded, the board, through Mr. Burton, formulates a document with the questions and answers and distribute to the profession so that sheriffs have the answers at the desk and they don't have to bombard you or refuse to do the work or send the applicants away. The last thing we want is those applicants not receiving access to justice. So I'm hoping that we have some sort of drafted document after this conversation going out to all stakeholders. Very important issues have been raised by the NABC, which will hamper the litigants in terms of accessing sheriff's services. So I think I would say let's pen the issue of locksmith until we have a directive, which needs to be done as a matter of urgency, because the attachments, unfortunately, with the amendment to the Labour Court Act, litigants and yourself and the sheriff had the luxury of time when the matter was dealt with through the High Court, because the High Court attachments did not lapse. Now we don't have the luxury of time, and that is why there is slip-ups between your officers and the sheriff's profession, because the 4 months is so little time to do whatever you need to do, and you have so much of red tape in your departments that sometimes it's difficult to give the sheriff's instructions on timelessly so that we keep within the 4-month period. So I'm hoping that this dialogue is had as fast as possible between you and the board, and a proper directive is sent out to all stakeholders so that we have a way forward.
Okay.
Mr. Burton,
Thank you, Mr. Murigan. Mr. Setlahu, something else?
No, I just wanted to echo his sentiments that we need to get together after this and resolve these outstanding issues, provide clarity, and be able to move on. And of course, also work together around, complex issues of indemnity and others, as stakeholders, because we are all in, for our users. Thank you.
Okay. Thank you, sir. I've just got a question. I think we can move along, but I've got a question that I just need to pose to both stakeholders here, the CCMA and the NABC, in terms of application for review or application for, let's call it review, or applications for rescission of judgment. What is the expectancy? What does the two councils, whether it's the CCMA or the National Bargaining Council, expect from sheriffs once those documents are served? They're not served, but filed with the sheriff, informing them of the process pending. Because like I stated previously, in terms of the rules, only an appeal, whether it's High Court or Match Court, only an appeal stops the full process. But in terms of the cost effectiveness of what is happening for both parties, what is the stance of the National Bargaining Council and the CCMA when it comes to the completion of procedures once the sheriff has received notification of the appeal? Not even the appeal, my apology, the appeal, we know what we will do, but when it comes to the rescission of judgment application or a review application, what would the CCMA want us to do, and what would the National Bargaining Council want us to do? I will start with the National Bargaining Council. They've been quiet for a while, so if they can maybe just give us some guidance there. Mrs. Pue or Boniswa, Mbovane, somebody can jump in there.
Okay, thank you, sir. Thank you. I'm sorry. Yeah, we're a bit quiet because we're not really involved in paying for applicants. We only pay when the applicant is us as the bargaining council. It is something that we still need to engage with the CCMA because they're the one who accredits us. Now you're talking about what does the sheriff do when they receive an application for rescission or a review? I just want to give one example. I don't want to mention names. There's some companies that are just against, I don't want to say the law, but collective bargaining or the CCMA. When they get the award, they'll want to review the award instead of rescinding it at the bargaining council or do anything just to frustrate the process, you know? What I normally do, because I can pinpoint to those people, I know these companies because we are dealing with parties here at the bargaining council. We know our parties. I just go on, I just tell the sheriff to proceed. For instance, they'll say we are reviewing the matter at the labor court and they don't follow all the processes of the labor court, like paying whatever that they're supposed to pay. So I'm still saying, in case of a reviewal or a rescission, we just go on unless there's a law that will, unless it's an appeal, just like you're saying. But I just also want to mention that I'm happy that we are engaging with the Board of Sheriffs. I just wish that we could have such a forum in where we have jurisdiction. For instance, some bargaining councils are national, some are regional, you know, to have such forums in, like in Gauteng, maybe in Durban, because what I've realized that sheriffs don't operate the same way. I'm not going to say who's sheriff because I don't want to put people in problems here. But there's some sheriffs, when you deal with them, they're so quick, they're so efficient, everything just goes well. There's some sheriffs, they'll always come back and say, I don't know where this shop is. You have to go to the sheriff and say, come, let me show you. Is this not the shop? I don't know what happens in such matters. That's why I'm saying this is a bigger forum. I just wish we could smaller forums like in regions, like in Johannesburg, where we could engage with those sheriffs that are in those regions so that they understand how the relationship between the bargaining councils, the CCMA, and the sheriff, because we're in this thing together. And I'm happy that the CCMA is here. They realize the problem that we're having when it comes to funding the applicants, because that's something that we still need to engage the CCMA about because we have this big problem. And thank you.
Thank you very much. Thank you, ma'am, for your response. Thank you, Mr. Murigan. So I can positively confirm that when it comes to any national, whether national bargaining council matters, unless it's a properly issued appeal in terms of the rules and the securities have been paid at court, the sheriff will proceed with the action until such time as the National Bargaining Council will stop them. So I just need to confirm that, but you were very clear in your instruction. Thank you very much. If Mr. Dube can maybe respond to us, or even Mr. Boyson, he's been very quiet. Should we put him in the hot seat? If Mr. Boyson can maybe respond just in terms of the same question, I would appreciate it. Thank you, sir.
In terms of a rescission, the rescission would stop the process, and that's within terms of the CCMA rules and legislation, in terms of the judgments that we've seen from the courts as well. A review would not stop unless the Labour Court specifically stays the enforcement of the award. Unlike our counterparts in the bargaining councils, that is the difference. We don't have the luxury of instructing sheriffs to proceed once a decision has been granted by the commissioner. Thank you.
Okay, thank you. So I think the clarity that we should just receive, or that we would just, is once the rescission application is filed with the sheriff's office, we then stop that procedure and we will send a copy of that in the form of a return and an annexes to the relevant CCMA office or to the applicant, so that he can then take it to the issuing authority, whether it's Benoni office in our area, whether it's Johannesburg. It will then stop that. So if you understand, it's not, but the review won't. The review doesn't stop, but the rescission application does.
Yes, the review is only if the court specifically orders that it stayed.
Okay. That's very clear. Thank you, Mr. Morgan. Over to you.
Thank you, sir. Thank you, Ian. I want to pose another question from the stakeholders from the NABC and CCMA, which was raised that they say that the use of email to forward enforcement documents as opposed to postage, which is far more costly, unreliable, and causes delays in enforcing claims. They want to know whether they can post or email the enforcement awards to sheriffs. The response to that is very simple in that Rule 41(8) clearly states that the sheriff must present the original document when he's demanding satisfaction of the judgment debt. Now, as much as sheriffs understand the predicament of cost incurred in posting or in terms of the applicant incurring the cost to come and drop the documents off to the sheriff's office, unfortunately, if the sheriff now accepts an email copy and if the matter is challenged by the respondent, then the sheriff becomes a party to the dispute because he hasn't complied with the rules. And remember, stakeholders, that these respondents will find anything, they would pick on anything just to prevent the execution process from being carried out. So as much as the sheriff would want to assist you, he is protected or is governed by the rules. Rule 41(8) specifically states that the sheriff is required to present the original documents to the respondent and then demand satisfaction. Now, as I said earlier on, a lot has changed when the rules moved from the High Court to the Magistrates Court. The High Court is very much more relaxed. It gives discretion. It allows the sheriff to present the mandate or to give and copies to the sheriff. It allows to a certain extent through a court order to give email for the sheriff to email service at some stages through a court order. But the Magistrates Court is very, very prescriptive. So your question there, can you email, is a bit problematic.
Mr. Morgan, just to follow up on that, just to give clarity to the stakeholders as well. The Labour Court, in terms of the High Court rules, they can, but when it comes to the Mag Court rules, you cannot receive emails. Just as a point of clarity.
Thank you, sir. I just want to see if there's anything else that or the stakeholders raised a question again, Mr. Burton. What are the time frames for a sheriff to respond to an enforcement order? So in other words, what are the time frames that the sheriff would use to serve, would require to serve or execute the enforcement award? Would you be able to assist us there? An estimate?
Thank you very much for putting me on the spot, because that is a very difficult question to answer. If I have to look at the whole profession, very difficult. My own office, the rule is very clear. When you go to the execution or service, it says service must be effected without any avoidable delay. But execution of the awards are sometimes not as easy as it. You'll find that you might find that the address you're going to might be locked. There are so many conditions and circumstances that can determine the time period. But yeah, I personally, and this is only me personally, I have a return time on certain documents in my office, and this is just for accountability and due diligence. And we give that to the applicant when he brings in the document to say within so many days, whether it's 5 working days or 7 days, contact the office to find out what has transpired. Will the document always be served within that time limit? Definitely not. Some might be served the next day, some might take 2 weeks to serve, but within reason. So I think it's very appropriate that find out the reason for the non-service. If the document has been with the sheriff for 3 months, then yeah, there might be some other reasons, but personal opinion, without avoidable delay, and give the applicant the opportunity to at least follow up within a certain time limit set by yourself as the sheriff, but it's difficult to give that answer directly to the CCMA or to the National Bargaining Council, because it all depends on the area where the sheriff is from. You might find that a sheriff has more than one jurisdiction and he has to travel 500 kilometers between the various jurisdictions, and he only goes there once a month because he only gets one document for Noport, for example, but he's in Graafrenet. So cost effectiveness to travel for one document, it would not be cost effective to charge the CCMA the traveling for that document if he doesn't have other documents to share. So I think that is, yeah, if the sheriff in his own office has accountability process in place, he can determine the amount of days, but at least give the applicant a time period to come back, or just to phone in and say, okay, ask whether the document's been served or what the delay is. Thank you, sir.
Thank you, Mr. Burton. Another question was posed by the stakeholders is what are the duties of the sheriff in respect of CCMA awards? It's a very, very broad question. I'm hoping you can assist me in responding.
Short and sweet, to give effect to the award as it was issued. But that won't be satisfying to everybody, or it won't satisfy the question. I think what we need to understand is that the sheriff is bound by the mandate of the document. 4 corners of the page is his mandate, and which is governed by the Act and the rules in terms of the match court when it comes to the CCMA. So, as the bottom line is to give effect and to execute the warrant or award to the best of his ability, so that the claim can be satisfied. Should we now sit down and discuss everything that happens during the execution process, I think we'll sit here for another 3 hours, because the scenarios and the circumstances and the conditions and what you might not find will keep us very busy. But at the end of the day, the sheriff is there to give effect to the award that was granted on behalf by the CCMA, on behalf of the applicant, to give him the best outcome possible. It's not always possible. It isn't. The person he got an award against might not have enough to cover his claim and satisfy it. But the sheriff's duty is to do due diligence and do it to the best of his ability. Thanks.
Thank you, Mr. Burton. Mr. Boyson wants to come in. If Mr. Boyson, do you want to come in here?
Thank you. Just a point of clarity, which was asked from one of the attendees from the CCMA to be raised, that to just specify that the rescission application must be lodged with the CCMA itself, because then we kick in our processes, and we in an ordinary sense would then notify the sheriff of the same. Thank you.
Thank you, sir. Thanks. We'll take note of that and obviously adhere to that.
Can we just confirm that point, please, Mr. Morrigan? If I understood the gentleman, if I understood Mr. Boyce correctly, we will, as a sheriff, you will only stop with your execution process and pend it once the application has been properly filed with the relevant authority, with the CCMA. So not just receive a copy on your table to say we are still filing in due course. It must be a filed copy of which the CCMA stamp will appear on the document. That's 100%. Thank you very much. Thanks, Mr. Boyce.
Thanks, Mr. Burton. Mr. Josiah wants to know, in other words, we cannot serve execute the enforcement award if the document is emailed to our officers. I think we answered that question just now when I gave the rule, when I quoted the rule, in that it's required that you have the original documents with you and obviously present if demanded to see it by the respondent.
Just Mr. Morrigan, Mrs. Titus has her hand up.
Sorry, I can't see that. Yeah, Mr. Titus, you want to come in there?
Thank you, Mr. Burton, Mr. Morrigan. Just a question to the CCMA. How do the staff members, like when the people actually go, for application for the awards and stuff, how do they allocate, or do they work with the sheriff's jurisdiction lists, or just randomly send the people to any sheriff's office? Because I incur a lot of problems where everybody are being sent to my offices, and then, you know, my office it's not so easy. Then the person will come to my office, and then, for instance, they need to utilize 2 taxis to get to my office, and then only to realize that, no, they must actually go to Simonstown's office. So I just want to find out, how do they, even I've got problems with Johannesburg as well, where everybody is phoning me on my cell phone. They issue my cell number to the applicants, and then people argue with me, but your number has been given as being the sheriff of Cape Town. And meantime, we're 18 sheriffs in Cape Town. And then I'm inundated, even over weekends, and I must sit and assist people with who actually, you know, refer them to which office they. So I just want to know how the people that issue these documents, how do they send people to the different various sheriff's offices? Thank you.
Mr. Boyson or Mr. Marwa, you want to come in there?
Yeah, no problem. Look, all offices of the CCMA have got the list of all the sheriffs within their respective areas. We have heads of provinces here who are listening and are going to try and look into that in their respective offices to ensure that we are complying, because from what I understand, it's an issue for applicants having to travel, you know, to the wrong sheriffs and have to incur costs having to travel to the right sheriff later. So if that happens, we take note and it should be corrected going forward. Thank you.
Thank you, sir. Thank you so much for that. Mr. Burton, I don't see any further questions on my list here. Online, do we have any further?
On my side, I'm just having a look at the, can you see the Q&A questions, or can't you? A lot of the Q&A questions have been covered in terms of, because a lot of them, you know, focused around the Rule 38 and indemnity, who's giving instructions. Those have basically all been attended to. So if there's nothing else that is, let's call it urgent, or we can't call it urgent. If there's nothing that anybody else wants to add, or anybody else wants to ask, I think we can call this meeting for the day. From
before you close,
no, sure.
Before you close, I think something that comes to mind, and looking at the various questions raised and the various issues that we spoke about, especially the benefit of the applicant. And I think that's the party that this whole discussion is all about. How do we improve the lives of those people? And I think it's a discussion that was that we had at the board at some point as well. And I think you and I had this discussion at some point as well. Maybe it's time that the CCMA and the National Bargaining Council and the board considers putting together a pamphlet that explains to the applicant the process and procedure that is followed once the enforcement award is issued. Something that, you know, that when the applicant goes to the CCMA and is handed the enforcement award, something that is given to him in a language that he can understand, and he will understand or know exactly what he's expecting when he comes on the other side to the sheriff's office, and what process, because very often we find that the applicant really does not understand the next step, or the sheriff finds it difficult to explain to him what he needs to do and how he needs to do it. And what the reason I'm raising this now again is listening to the National Bargaining Council is to be more prominent now that these applicants that's coming out of the Bargaining Council will require some sort of guidance. And so maybe this idea of a pamphlet should be discussed further again. Should be considered
Thanks,
further
Mr.
again.
Morgan. Thank you. Just to reiterate on that, I know the board went forward with an initiative to do exactly what you just suggested for the small claims court. And I must say, it is the documents the pamphlets that have been printed that we distribute, whether it's to the SAPS, whether it's to the clerk of the small claims court to distribute to people, is having great effect because they know the process, they understand what is expected of them. But Mr. Murugan, thank you very much. I really do appreciate it. Before I say, give hand over to Mrs. Titus to end this to us, this meeting for us, Mr. Setlaku, is there anything that you would still like to add? I'm also going to ask Mrs. Maggie Poe if she would like to add something and just end off before we hand over to Mrs. Titus to say the thank yous.
Okay, no, thank you. Thank you very much, Mr. Baton. Look, we appreciate the session. I think it was very, informative, helpful, and the commitments we have made, especially stakeholders to meet and try and resolve some of the challenges for the sake of the vulnerable. SC Boys will distribute the list, from all our offices, and please feel free to contact those people anytime there are issues. We are here for the same purpose, and let's resolve whatever outstanding or any new issue that may, arise. Of course, for us, the issue of Rule 38, as we have said, it's something we thought we have resolved permanently, but I guess we need to go back to it, and we commit to, meet with you and see how best we can really work on this, have our internal, processes here, and look at it. We will look at the issue of the pamphlet as you have advised, see if it is doable. Unless we already have it, we will check and then look into that or other means that, are there for us to, continue to assist our users in understanding processes. Although what we are doing currently is as and when they collect, we make time to explain to them, and we understand some of the challenges that they may forget and they may have their expectations, and sometimes get the wrong advices from people outside the CCMA, because those are some of the challenges. But otherwise, thank you very much, the board and NABC as stakeholders. Thank you for this session. We hope to get together regularly and resolve challenges that we face, as a team. Thank you.
Thank you, sir. Mrs. Poe?
Okay, on behalf of the NABC, we also do appreciate the invite. We have been empowered by this session, and we have also noted in the chat box there that a pamphlet will be appreciated so that the employees that we work with would know how to direct such applicants when they knock at our doors. We would be meeting with the CCMA to settle some of the issues that regards to, especially the funding. It is not a matter of the bargaining councils not wanting to assist the vulnerable, but it is an issue of financial constraint. And also, once we have settled the matter with the CCMA, we will advise the Sheriff's Board accordingly. And we have also undertaken to communicate with, or we are undertaking to communicate with all our member bargaining councils that they should communicate or share the outcomes of the reviews and rescissions, applications and settlements with the sheriff boards. Those are, unfortunately for now, the only undertakings that we can make. We are prepared to go into partnership with the Board of Sheriff and the CCMA to resolve the issues, because we believe that an injury to one is an injury to all. We also would not want to frustrate the vulnerable. They are looking up to us for finality, and if there is anything that we can do to assist, that we are prepared to do within limit, obviously. Thank you, sir.
Thank you, ma'am. I appreciate that very much. Without keeping anybody any longer, I'm going to ask Mrs. Titus, our Deputy Chairperson of the SA Board for Sheriffs, if she will do us the honor in closing.
Thank you, Mr. Burton. I would like to take this opportunity to thank everyone for their participation in this fruitful session. A special thanks to our esteemed guests who took time out of their busy schedules to attend this information session. And last but not least, I would like to thank Tertia from the CCMA, as well as Shana from the National Bargaining Council for your assistance, and also our training committee and everyone that worked hard to make this a fruitful session this afternoon. Thanks very much to everyone. Have a nice day further. Thank you. Okay.